Lie number one. In January 2004, the prosecuting attorney, in arguing before the Georgia Supreme Court, denied that the jury affirmatively found consensual sex.
We are not conceding the fact that the jury affirmatively found this was consensual sex.
And yet, in October 2003, the prosecuting attorney participated in a national television show in which two jurors announced that the jury conclusively determined the sex was consensual.
Every juror agreed that it was consensual.
After we heard the evidence, we pretty much thought there was consensual sex between two teenagers.
Lie number two. The accuser's attorney similarly goes on national television arguing that the jury did not affirmatively find consensual sex.
The majority of the position of the defense is based upon the premise that this was consensual sex. However, nothing could be further from the truth.
15-20 minutes to come to a conclusion on the rape and all of the charges that hinged on rape. We knew that it was consensual sex.
Lie number three. The prosecution continues to maintain they have a strong rape case.
I thought the rape case was very strong, or I would not have taken the case to trial.
I didn't have a doubt. From after the state had rested, I knew that nothing they said added up.
You're 2 of 12. Did all 12 feel that way?
Pretty much.
Pretty much.
Lie number four. The prosecution claims that there is no evidence of consensual sex.
You have to look at the absence of any indication on anybody's part that this was any sort of consensual sex act. There's nothing to indicate that this was consensual sex.
One school student says Dixon is telling the truth.
The next day he gets arrested, and I asked her, I said, well, why did you do this? When you told me yesterday that it was willingly, and she just went into tears. She said that she was scared of her father because of what was going on. She said her father was a very racist guy. She was nervous of what was going to happen if her father found out that she actually had sex with a black person.
Lie number five. The accuser's attorney misrepresents the evidence of injury.
If you read the trial transcript, sir, you will clearly see that she sustained bruising to her inner thighs.
The bruises you described, are these bruises that are down the leg or down on the thigh, or are these bruises right up in the vaginal area?
They were at her vaginal orifice and her hymen.
So we're not talking about a bruise down on her leg?
No, sir. We're talking about a bruise on her labia.
Taken from rape nurse testimony, trial transcripts, page 352.
That she had a bloody lip.
And you said she had blood on her lip?
Yes.
Well, did you think it was chapped lips, or did you think it was something else?
My opinion? I thought chapped lips. So that is where I'm going to leave it.
Taken from testimony, prosecution witness Miss Eli, pages 112 and 113. Did you have blood on your lip that afternoon?
I didn't know I did.
Had you been biting your lip?
Probably, because it is a habit.
Taken from accuser testimony, trial transcripts, page 152.
And that she had bruises to her arms.
You know very well, sir, that
sex.
3 witnesses testified that the bruises on her arms were there before the encounter with Dixon.
No, sir.
If you'd even bring that
no,
up.
sir, not at all. That was not the testimony of the court. In fact, the only testimony that was given was the fact that there were no bruises at that time.
2 students testified that they'd seen bruises on the girl's arm hours before the incident occurred.
The pictures that were presented to us in the jury room was different location what she testified on. They weren't in the same place where she said he held her.
When she testified, she said that he had taken her pants down with his knees and his elbows. And when we as a jury were going over the information, we found it impossible.
Lie number 6. The prosecution states that they have appropriately applied the child molestation law.
We absolutely deny we were overzealous in our prosecution.
But he's being punished in a fashion that no one else in the state ever has under the statute.
So anytime there is consensual sex between teenagers who fall within the right legal parameters, there is the possibility that one or both could be charged with child molestation.
Yes, Your Honor.
Would it be fair to say that you put the aggravated child molestation charge on there as a backstop in case you couldn't get raped?
That's part of the reasoning.
Why is Marcus Dixon any different than anybody else that's charged with aggravated child molestation?
This is the only time in the history of Georgia that a kid has been sent to prison for 10 years for consensual sex.
And I think the prosecutor has abused the law and misapplied the law.
When you co-sponsored the Child Protection Act, what is it you set out to do?
To really protect children from predators. Marcus Dixon is not a predator. He's not a child molester.
No, by no means. Marcus is not a sexual predator.
Lie number 7. The prosecution maintains that justice is served.
Jury of his peers found him guilty of really nothing more than consensual sex with a schoolmate who was 2 years, 7 months, 18 days younger, and that he did no harm to her beyond that consistent with her state of virginity. Yet for that, he is facing minimum 10 years in prison.
The punishment in this case was just. The outcome was just.
What is the effect of an overzealous prosecutor misapplying the law? Jurors that are stunned, shocked, and crying.
The jurors in that room, the looks on their face was just devastating. Like, what have we done?
I think every juror on the jury gasped. And it took everything I had not to just cry, because he didn't deserve that. He doesn't deserve it.
Barry, Ken, I'm so sorry. Please understand this was not our intention.
It's not your fault.
Marcus does not deserve to be in prison.